In American legal history, atheists have not been trusted to give testimony under oath or serve on a jury. As of 1938, 7 states explicitly prohibited testimony from anyone professing disbelief. 8 others allowed impeachment of witnesses based on his or her disbelief. Dying declarations were not considered acceptable when atheists made them, apparently based on the notion that they might be lying because they did not fear punishment in the afterlife. Dying declarations have often been considered admissible by the courts because the dying person presumably has nothing to lose, and being so close to death would not wish to imperil his or her immortal soul. The dying declaration of an atheist who told his sons who had shot him was remanded back to trial court in 1920 with instructions that the victim's atheism should be admitted and used to help undermine his credibility. David Copsell states that as late as 1953, 8 state constitutions required belief in God to hold public office. Discrimination against atheists is a civil rights issue and has been deemed as such by the American Civil Liberties Union, ACLU, the Duke Bar Journal, and the Journal of Criminal Law and Criminology. Yet, let us look at the reality. Colonial-era Baptist minister John Leland once observed, "If a man merits the confidence of his neighbors in Virginia, let him worship one God, 20 gods, or no God, be he Jew, Turk, pagan, or infidel, he is eligible to any office in the state." Leland was not the only one to think this way, as we have previously mentioned. During debate over the Constitution, a South Carolina delegate named Charles Pinckney sponsored a measure stating that no religious qualification would ever be required for public office. The provision now found in Article 6 of the United States Constitution states that those elected to public office may be bound by oath or affirmation to support this Constitution, but no religious test shall ever be required as a qualification to any office or public trust under the United States. This language is inconvenient for the religious right. Not only does it debunk claims that our country was founded to be a Christian nation, it also makes clear that atheists are duly qualified to hold federal office. So, atheists are free to run for the House of Representatives, the Senate, and the presidency. What about state and local governments? Remarkably, the answer to those questions was not sorted out until 1961. Roy Torcaso, a Maryland man who served as a bookkeeper and office manager, was asked by his employer to become a notary public. Maryland had a constitutional provision limiting public office to those willing to make a declaration of belief in the existence of God. Torcaso, an atheist, refused to make that statement. Torcaso sued, and his case went all the way to the Supreme Court. In a unanimous ruling in Torcaso's favor, the court declared in Torcaso versus Watkins, "We repeat and again reaffirm that neither a state nor the federal government can constitutionally pass laws or impose requirements which aid all religions as against non-believers, and neither can aid those religions based on a belief in the existence of God as against those religions founded on different beliefs." Maryland's provision, along with those in 6 other state constitutions, was made null and void. Pennsylvania's is perhaps the most strangely worded. It held that public office was open to anyone who acknowledges the being of a God and a future state of rewards and punishments. So to hold office in the Keystone State, you had to believe not only in God, but also heaven and hell. Torcaso should have settled the matter, but in 1990, Herb Silverman, a professor of mathematics in South Carolina and an atheist, had to go to state court to challenge that state bars on non-believers holding public office. South Carolina's provision was very straightforward in its bigotry. It declared, "No person who denies the existence of a supreme being shall hold any office under this Constitution." Silverman applied to become notary public to test the measure and won a unanimous ruling in his favor from the South Carolina Supreme Court. Now, back to early America. The issue of separation of church-state and religious freedom in the early years of our nation were brought to a head in Virginia around 1784. Patrick Henry, soon to be elected governor, sponsored a bill that would tax its citizens for the support of the Christian religion or of some Christian churches. The bill would have allowed citizens to choose which churches they wished to support among competing religious denominations. James Madison found the proposal of plural establishment obnoxious and wrote one of the greatest statements of religious liberty ever penned, the Memorial and Remonstrances Against Religious Assessments. The memorial listed 15 reasons why citizens should not be taxed to pay for religion, and also maintained that religion does not need the state to support it. It is an eloquent and moving statement. Too few contemporary Americans have been exposed to its ringing words. The opposition to taxation, groups which included dissenting denominations such as the Baptists, circulated the memorial around the state of Virginia. When the Virginia General Assembly met in 1785, lawmakers were faced with stacks of petitions against the taxation proposal, and the bill was soundly defeated. Madison was emboldened by such a success and pushed for the passage of Jefferson's earlier 1779 bill for establishing religious freedom. The bill stated, "No man shall be compelled to frequent or support any religious worship, place, or ministry whatsoever." The bill also made clear that taxing citizens for church support was tyrannical. Jefferson was delighted when his bill was passed in Virginia in 1786. He later wrote to a friend that he wanted his bill to protect the Jew and the Gentile, the Christian and the Mohammedan, the Hindu, the infidel of every denomination. Madison was the chief author of the Constitution of the United States, and he had a very important part in developing the Bill of Rights. The First Amendment was developed in 1789. The Constitution is mainly silent on religion, except for Article 6, which bans religious tests for people running for public office. The Constitution, except for the pro forma words, "the year of our Lord," in the date, does not mention God, Jesus Christ, or Christianity, and the omission was deliberate. Robert Boston states that the First Amendment encapsulates the separation of church and state in two ways. The first portion of the amendment reads, "Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof." Such a statement does not merely mean that the government could not establish an official church, but also that no laws should be created funding, promoting, or establishing religion. The second part, the Free Exercise Clause, prohibits laws that do not allow the free exercise of religion. There is a question concerning the origin of the phrase separation of church and state. Robert Boston states that the words appeared in Jefferson's famous letter to the Connecticut Baptists on January 1st, 1802. In that letter, he refers to the sentences in the First Amendment quoted above, that Congress would neither make a law establishing an official religion nor prohibit free exercise of religion. Jefferson declared that such provisions were thus building a wall of separation between church and state. It is important to keep in mind that the Bill of Rights was limited to Congress at first, so it did not apply to the states. As a result, church-state cases were rare in the early years of the American Republic. After the Civil War, Congress passed the 14th Amendment, which imposed portions of rights on the states. And in 1925, Gillow versus the United States, the Supreme Court said the states were bound to protect freedom of speech. This process was called incorporation, but some of the U.S. Supreme Courts refused to accept the very clear language of the 14th Amendment. The applicability of the First Amendment's Establishment Clause took some time to be settled with regard to the states, even after the passage of the 14th Amendment, and disestablishment in the states is still not settled according to some theocratic justices. In his written opinion in the New Dow decision regarding the use of "under God" in the pledge, U.S. Supreme Court Justice Clarence Thomas went out of his way to make his legal case that somehow the First Amendment's Establishment Clause is not applicable to the states, even though the rest of the First Amendment apparently is. The Free Exercise Clause was applied to the states in the 1940 case Cantwell versus Connecticut. Then in 1947, the Establishment Clause was adopted in Everson versus Board of Education. Cantwell was the case of a Jehovah's Witness and his sons who wanted the right to proselytize on a public street in Roman Catholic neighborhoods in Connecticut. The state convicted Cantwell of soliciting without a permit. The Supreme Court overturned the state decision. The Everson case, involving using tax money to bus children to parochial schools in New Jersey, was not a complete win for church-state separation. However, the entire Supreme Court endorsed the solid wall between church and state.